On this topic, I'll end off by saying, at all times, the judiciary, including the justice system, will never be intimidated by any politically charged utterances or parties. There is no room in a court of law dealing with a criminal offense for the court to enter into politics at all. I just need to find my rhythm as well here. Right. What is apparent then is that people of this country are speaking as one. Crime is reaching astronomical proportions, and the courts are required to do all in its power to combat the situation and to ensure that all would-be offenders or offenders who are still to be brought before justice faces the full arm of justice. And surely if this is not done or goes unchecked, as I've stated, it will result in the perception that crime is an inevitable consequence of life in South Africa. It must further be noted, as much as the rights of the accused has been emphasized, and correctly so, as it is enshrined in our Constitution, members of society too enjoy rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all. I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Caesar. Just want to get to the relevant part. Yes. Gracious. The matter submitted by the state being Romeo Jansen and the state, case number CANR 220/18, delivered by D. Van Sale, then DJP, and by the defense, that of the Malundana case, case number CC20/2024, delivered by Brooks J. Now, in this instance, it was interesting to read both. And what is abundantly clear is that in the matter presented, the Malundana case, the facts are completely opposite as the ones we are dealing with today. In the matter submitted, the Malundana matter, was a gentleman of 62 years old who had, after a very long period of time, secured employment as a security officer protecting a school, which led to him firing a handmade firearm. The difference in that matter, which the judges considered as sentence and mitigation of sentence, is the accused there pleaded guilty. he had also spent a period of time incarcerated, 4 months in custody before. Further, he was also a first offender. He had assisted the victims at the scene, and he himself had called the police to come and assist. He had also contributed to the costs of the family who suffered in the incident. That is the set of facts unique to that matter. Now, what is interesting in the Janssen matter, counsel argued yesterday that the matter cannot be of assistance to the court. I disagree on that aspect. Indeed it was. Because I think it was said that he had previous convictions, Janssen. But when you read the actual judgment, the judge states clearly that the accused was treated as a first offender despite having previous convictions. So that is not relevant. That was, he said, and he was found to be, or having been in possession only. There wasn't a crime that was committed on the day he was arrested with the firearm. And then interestingly, after being asked by the defense that all people be treated equal, it was submitted that Janssen is a gangster, therefore a member of Fat Boys, and therefore custodial sentence is in order.